This is Barry Salma speaking for my blog, Salma on Insurance. Today, a little bit away from insurance, but a case about how unmitigated gall of a few individuals to abuse an elderly bishop and his church to obtain title to the church by fraud, only to find that it was defeated by an intelligent court, concluding that it is villainous to steal church property from sick and an elderly bishop. In Testimonial Cathedral Local Church of God in Christ versus Equity Key Real Estate Option LLC et al., the California Court of Appeal on November 18, 2025, dealt with Equity Key acting through brokers Stephen Sharp and Frank Wheaton, a trusted advisor and friend of elderly Bishop Jimmy Hackworth, presented a deal supposedly for a $4 million life insurance policy on Hackworth's life, with Equity as beneficiary. In exchange, Equity paid Hackworth $400,000 up front. To qualify, Hackworth for the large policy church real property on Southwestern Avenue in Los Angeles was temporarily transferred into Hackworth's personal name by a 2008 handwritten grant deed and a 2009 printed grant deed. Hackworth, in his 70s, disabled, with hand tremors, and daughter Angela Hackworth Wilson, the church administrator, testified they were repeatedly told that this was purely a personal life insurance deal for the bishop. The church was not involved and no lien or third-party interest would attach. Those were lies. Wilson signed most of the documents, including the performance deed of trust, the PDOT, under a power of attorney because Hackworth physically could not sign his name. She testified she was rushed, did not understand the documents, raised concerns, and was falsely reassured. The real estate investment agreement at PDOT were dense, small print documents that appeared to be with an individual qualified homeowner, Hackworth, but described the church's real property and gave Equity Key an option to acquire it plus a share of appreciation secured by the recorded PDOT. Church first discovered the recorded PDOT lien in 2018-2019 while attempting to refinance. It sued in 2019 to cancel the PDOT and the deeds. The trial court first made findings about the statute of limitations. 1. Claims to cancel the grant deed were time-barred because the church knew it was transferring its own property in 2008-2009. 2. Claims to cancel a PDOT, the lien instrument, were timely. 3. The governing statute, 3 years for fraud, Section 338D, the court noted also the 4-year statute would apply to straight cancellation declaratory relief, but fraud controlled here. 4. Delayed discovery rule applied because the cause of action does not accrue until the plaintiff has actually or on inquiry notice of facts constituting the fraud. 5. Substantial evidence supported the finding that the church had neither actual nor inquiry notice of the lien until 2018-2019. 6. Credible testimony that Sharp Wheaton misrepresented the entire nature of the deal. 7. Confidential trust relationship with Wheaton, the longtime legal advisor and church member, relaxed the normal duty of inquiry. 8. Oral misrepresentations lulled the church into inaction. 9. Failure to read dense documents was excusable in light of fraud in the inducement. 10. Mere existence of recorded PDOT in public records was insufficient to trigger inquiry notice absent some reason to search title. 11. No evidence contradicted the church's witnesses. Equity Key called no percipient witnesses from the 2008 closing. 12. Merits of the fraud in the inducement. A. PDOT was voidable and canceled because material misrepresentations induced execution. The deal was falsely presented as only life insurance with no church involvement or lien. And B. Sharp was Equity Key's agent, and Equity Key bore the responsibility. 13. Equitable relief. As a condition of canceling the PDOT, the court ordered the church to repay the $400,000 Equity Key had paid Hackworth in 2008 plus interest, and judgment made cancellation effective only upon full repayment, creating incentive for prompt payment. The key legal takeaways from this case is that 1. Fraud claims, including cancellation of instruments procured by fraud, are governed by the 3-year statute with robust delayed discovery protection. And 2. Where a confidential or trust relationship exists or active misrepresentation lull the plaintiff, the duty of diligence is significantly relaxed or eliminated. 3. Failure to read a contract does not bar relief for fraud in the inducement when equitable remedies like rescission, cancellation are sought. 4. Mere recordation of a lien does not automatically start the statute running if the plaintiff had no reason to suspect its existence or fraudulent nature. And 5. Trial courts have broad equitable power when granting cancellation, rescission to condition relief on restitution, here repayment of the $400,000 benefit received. The judgment was affirmed in full. The church keeps its property free of the PDOT once it repays the $400,000 plus interest, and costs were awarded to the church. The Court of Appeal affirmed the trial court's judgment after the bench trial that 1. Canceled Equity Key's 2008 performance deed of trust and lien on church property because it was procured by fraud. 2. Found the church's 2019 lawsuit timely. And 3. Ordered the church to repay Equity Key the $400,000 advance. In my opinion, taking advantage of an ill old man and the church he served to steal the church property and get the pastor, the bishop, a $4 million life insurance policy and a $400,000 advance is egregious and obviously fraudulent, except to a fairly demented bishop. The court protected the bishop and his church from the fraud and used the delayed discovery rule to prevent the success of the fraud. Fraud perpetrators are people with no honor and have the unmitigated goal to defraud a sick old man to allow the fraudsters to take ownership of the church property controlled by Bishop Hackworth, who was physically unable to even sign the document. This video was adapted from my blog, Salma on Insurance. It is available free to anyone who clicks on the URL salma.com/blog. You can subscribe to the blog, and if you do, you'll receive notice of every blog posting, usually 5 or 6 a week, and you'll gain access to the more than 5,200 blog postings. You can also subscribe to these videos on YouTube or rumble.com. They're free. Please tell your friends and colleagues about this blog so that they too can subscribe to the blog and the videos. And if you're interested in further detail about insurance, insurance claims, insurance law, and insurance fraud, please consider for a very small fee subscribing to my Substack publications. Thank you for your attention.